Hello, everyone. We're delighted you're joining us today. We've received a ton of questions around the Department of Labor's fiduciary rule. We've coined this the DOL fiduciary rule mania. And effectively, how do you navigate the level of uncertainty that surrounds this rule, those recent court cases, and so on? So we are excited that you're joining us. A few housekeeping matters before we get started. We are recording today's conversation and plan to share it with you following today's session. As with majority of our webinars, there is an opportunity for you to get engaged and ask questions. Please use the chat box at the bottom of your screen. You can send questions directly to the panelists. Our plan is to take those questions up at any point in time. I'm getting a message that someone cannot hear me. To my fellow panelists, can you hear me?
We can.
Perfect.
Yes, we can hear you.
Excellent.
Yeah.
Let's keep going, and we'll start with a quick round of introductions, starting with Mr. Porteous.
My name is David Porteous. I'm a partner at Faegre Drinker in Chicago. I work in business litigation and routinely counsel clients in the investment management and broker-dealer space.
Thank you, David. Armin?
Yep, this is Armin Sarabi. I am Chief Compliance Officer and General Counsel with Alphastar Capital Management in North Carolina, and a current user of InvestorCom products and a self-professed expert at the DOL rule.
Fantastic. You're here for the right reasons then.
That's right.
Good afternoon, everyone. I'm Victoria DeLucia, and I'm the Director of Institutional Engagement in the Compliance Services Division at Confluence. I work with investment advisors and broker-dealers in implementing customized compliance programs, performing annual compliance reviews, mock regulatory exams, independent AML exams, and, of course, retrospective reviews to satisfy DOL PTE 2020-02. I also serve as the designated Chief Compliance Officer to an SEC registered investment advisor, and have been in compliance roles for the last 30 years.
Thank you, Victoria, and welcome. Right time, right place. Mr. Barnes?
Hey, thanks, Bar. I'm Randy Barnes, Director of our Product and Sales Engineering and Product Development here at InvestorCom. Also stationed here in lovely North Carolina, just down the road from Armin. And I am not an expert in the Department of Labor retirement security rule, but I did stay at a Holiday Inn Express last night, so that qualifies me for being on the panel.
That's good to know, Randy. Thank you for investing your time here with us. And for folks who maybe are unfamiliar with me, my name is Parm Nasseri. I'll be your host for today's conversation. And again, for folks who haven't come across InvestorCom in the past, we are a leading regulatory software provider for wealth managers across North America. And our award-winning platform is known for its intuitive design and for helping our clients eliminate compliance risk and foster growth for their businesses. Without further ado, jump into our agenda for today. We plan to recap the DOL's intentions behind the retirement security rule. We'll dive into the recent court decisions and what they mean. In addition, we'll focus majority of today's time on best practices for remaining compliant and growing your practice. As always, please leverage the chat box, engage with our panelists, and we can take up any questions that you have at the end of today's session. Okay, the retirement security rule has been a journey. There was a 2016 edition, and as well as the most recent one from starting in 2023, and the conversations we've had to date. David, maybe I can start here, and let's start with an overview of what the DOL was looking to accomplish with the retirement security rule, and also how the industry would have been directly impacted by this rule had it been going into effect.
Thanks, Parham. So a lot of this, as you just identified a minute ago, relates back to both the prior DOL rule that the Obama White House implemented in 2016, which again was vacated in 2018. This was resurrected in 2020, where DOL issued new guidance reinterpreting fundamentally the 1975 rule, the fiduciary interpretation, for which it was a 5-part test as to whether or not a particular type of advice would constitute fiduciary advice, and for which, under DOL, receiving compensation in connection with it would give rise to potential conflicted advice for which you'd need a prohibited transaction exemption to engage in. As a result of an Arizona court decision in 2023, which had basically struck down or concluded that the DOL's interpretation of regular basis, which was one of the elements of the 5-part test, that in essence, whether and to what extent one-time advice to rollover plan monies to an IRA could be construed as regular basis, which is what DOL's interpretation was as of 2020. Arizona court struck that down and said that's arbitrary and capricious. So then in 2024, they implement new guidance to basically get around this, which is to basically say, well, we think one-time recommendations can be fiduciary in nature. So this is the essential tension that's been going back and forth, this ping pong, is the utilization of DOL and the ERISA construct to get at the advice being rendered to an IRA, whether it's as part and parcel of a rollover into an IRA plan or between IRA, transferring an IRA from one firm to another, whether and to what extent the nature of the advice being rendered there is such that it would be deemed to be advice being rendered on a regular basis. And to the extent that your interaction with a potential plan participant is one-off, historically under the 1975 interpretation, that would not meet the regular basis prong of meeting the definition of being a fiduciary. And that is really what the goalpost moving is really surrounding the regular basis. So the consequence of the 2024 proposal was that a one-time recommendation of an investment advisor or an insurance agent to a retirement plan, or participant in a plan, or an IRA would constitute fiduciary advice. As a consequence of a couple of different decisions coming out of Texas, the DOL's new rule that was proposed to go into effect in September of this year, and then some implementation dates in September of next year, the effective dates of the DOL's new fiduciary rule, including its new regulation and redefining fiduciary investment advice and the related amended prohibited transaction exemptions, are stayed. So that puts us back into the state of play that we were in before they updated it earlier this year, which is the 5-part test that I was talking about in the first place that was implemented in 1975. So we're back to the state of play in which what regular basis means for purposes of establishing an ongoing relationship to impose a fiduciary obligation upon an investment advisor or an insurance agent in their communication with a customer, whether or not that rises to the level of constituting fiduciary advice for which the receipt of compensation could be deemed to be conflicted. So it's back to the state of nature as existed prior to the 2024 proposed amendments.
Thank you, David, for that wonderful summary of the state of play today. And Arvind, you self-profess to be an expert in this arena. Maybe I can pick on you. What are the general challenges and opportunities that you see ahead of us, given this recent stay from the courts?
Yeah, I think the I guess the best news that I would say is that that we get to stay the course for now, right? So at this point, I would hope that most of the firms out there who had regulatory obligations under the DOL framework, previously had figured out the processes and have all their policies in place and have probably already gone through a number of retrospective reviews at this point and so forth. So I think I think one of the just things to look forward to is that we don't have to immediately solve for any of these changes. We don't have to immediately pivot to try to scramble and meet a deadline by September and so forth. I mean, this court decision, really came down to the last, couple of months here. And I think a lot of us were just kind of sitting there wondering, are we going to have to move fairly quickly? Those of us who had an obligation to meet that September deadline. So certainly I think it's beneficial in that sense. So, as far as challenges, well, I think there's still sort of that question mark, right? Realistically speaking, I think that the DOL has, a specific agenda in mind here. They want to refine the rule that they, have already in place, for, and want to refine it in a specific way. And I think really the question is, are they going to continue to work on this? Maybe they'll try to find a different way to, address their, this refinement, making some changes. It's just all up in the air right now. So that's the challenge, is sort of the unknown variable in where this is going. But I think historically speaking, and those of us who've been doing this long enough, we just know that these things happen. Typically, when a new rule comes out, there's a number of firms that are just waiting to fire off challenges to it. Some stick, some don't. Eventually, things kind of wash out, and you end up with something that finally makes it to the book. So for now, I would just advise everybody to keep doing what you're doing and make sure that you're staying compliant.
Thank you, Armin. That's wise advice. I think there's certainly a lot of confusion in the industry. And Victoria, I'm wondering, as you're sort of interacting with multiple clients, some large, some small, what are you seeing given the level of uncertainty in the industry?
Yeah, thanks, Armin. I'm sorry. Thanks, Parm. I do work with a lot of different types of firms, and the one thing that I found interesting as I'm hearing the other panelists speak is I didn't hear from one single client that I work with that they were concerned about providing advice in the best interest of their clients. And, investment advisors are already a fiduciary, broker-dealers are subject to Reg BI. So that wasn't the hurdle that my clients were struggling with. Most of the questions that came my way were focused on how to handle the changes in IRA to IRA transfers. So under the original version of DOL PTE 2020-02, and apparently what we're sticking with for a little bit anyway, firms are required to conduct an analysis and document the reasons that an IRA to IRA transfer is in the client's best interest and deliver that documented analysis to the client. So under the amendment, PTE 2020-02 would no longer require that same documentation or disclosures on rollovers from IRA to IRA or from one account type to another. However, it would still impose the care and loyalty obligations, requiring the firm to undertake efforts to obtain information about fees, expenses, everything that they're doing right now, and make recommendation in the client's best interest. But even without a specific documentation requirement, I think it would be difficult for firms to demonstrate compliance with the care and loyalty obligations that certainly would continue to apply. And of course, without documenting the IRA to IRA recommendations. Certainly, in my interactions with regulators, they tend to be of the opinion that if something is not documented, it didn't happen at all. So firms were struggling with this. They finally felt comfortable with understanding the DOL PT requirements, and they were reluctant to pull back. And as compliance professionals, we're always under pressure to support the business in being efficient. CCOs wanted to continue to require the written rollover analysis for all recommendations. So that was a challenge. And I've actually seen some relief across the firms that I work with now that the rule has stayed. But of course, it stayed. It's not completely gone for the time being.
Thank you, Victoria. Really appreciate you sharing that, at least what you're seeing across your client base. Maybe, Dave, just for those who are particularly curious about the legal arguments maybe behind what the plaintiffs used to that led to the particular stays here. Do you mind sharing a little bit about that?
Yeah, if I can take a step back, I think some of this emanates in the first instance from the Arizona case that addressed the reinterpretation in 2020. The Arizona case was decided in 2023. And in that context, the court held, I'm really going to go focus more on what the holding is more so than the argumentation, because that's sort of the manifestation of what the arguments that the court found acceptable. In that context, the court said that the DOL's interpretation of regular basis with respect to one-time advice to rollover plan monies to an IRA was arbitrary and capricious. And in particular, they focused upon the fact that the participant's retirement plan, the component of providing advice to a participant in the context of a retirement plan, is one plan, and that the IRA is a different plan. And so whether and to what extent you have an existing relationship with someone in connection with their IRA, you can't sort of use that to say, just because you're advising them over there in connection with an IRA that you have for them, that when you also advise them in connection with a plan that they may also be a participant in, that you don't get to sort of roll the two together in order to create a regular, an ongoing relationship, regular basis. So that's how the Arizona court sort of tackled it. And then when we kind of roll forward into 2024, what we're dealing with is, you know, the effort by DOL to get around this hurdle of, okay, and in what circumstances will one-time recommendation of an investment advisor or an insurance agent to a retirement plan, a participant in a plan, or an IRA give rise to fiduciary advice? And so in that context, again, we're picking at, you know, this notion that, you know, the 5-part test had this regular basis. And in effect, they're trying to peel this back and find a circumstance in which you can be deemed to be rendering fiduciary advice to a person in a one-off context. And so again, sort of the efforts to get around that were challenged, and the courts in both the Texas proceedings basically find that, you know, we don't think you have a likelihood of success on the merits in establishing that the modifications you've made to say that a one-time recommendation with an IRA in particular, whether it's in furtherance of, you know, providing a plan for how you may be, say plan meaning financial plan, for purposes of advising them on an ongoing basis going forward. But in the first instance, that in and of itself doesn't give rise to a fiduciary relationship in and of itself. So it's really about sort of the tension between what constitutes a fiduciary relationship and the attack. And what the court sustained is, I think you're going to have a likelihood of success in establishing that, you know, peeling this back to one-time recommendation may not prevail. So that is stayed pending the court's ultimate determination on the case. So that's how it is that the reinterpretation, as I would call it, by DOL in 2024 has, you know, again, been stayed in that effort to convert a one-time recommendation into a fiduciary relationship.
Thank you, Dave. This is really sound feedback on what you're interpreting the states to be. I guess with this DOL deja vu that's taking place this time around, a lot of folks are going to be asking, you know, looking forward, and I think Armin and Victoria touched on this. Dave, in your opinion, what are the possible outcomes of this particular rule? And then if you're in the business today, how do you put the right chess pieces in place so that the business can be compliant going forward? Maybe I can start with you, Dave, and I'll go around the panels here.
Yeah, if I can pick up a thread of what Victoria was saying, which is, okay, so heading into 2024, firms that were adopting processes for purposes of complying and utilizing and relying upon 2020-02, in terms of duties of care and loyalty, as well as 8424, which would have been in existence for a while for insurance transactions. You had to have systems in place, particularly on the investment advisor and broker-dealer side. You were already implementing systems for purposes of best interest if you're a broker-dealer, and as a fiduciary, as an investment advisor, a similar analysis attaches in terms of whether or not a recommendation is in someone's best interest. And the SEC doubled down on that. in its adopting release for Regulation BI, as well as its statements to the duties of investment advisors in 2019. That in essence, in their view, a rollover recommendation is a call to action by an investor, and fiduciary duties in the case of an investment advisor, or best interest in the case of a registered rep, would attach. And so you need to provide people with thoughtful analysis as to the positives and negatives of doing so, with a particular emphasis on costs. And so insofar as that state of play picks up in 2020, in terms of the SEC's view of it, and more importantly, to the extent you're a dual IABD or you're just a broker-dealer, FINRA is also examining transactions for that as well at an account opening stage. Are you opening up an IRA? Was this IRA as a result of a rollover from a plan? Okay, what analysis did you do as to A, account type, but B, or kind of depending how you approach it, what analysis did you do to justify why is it this person should roll over out of a plan? Because it's a seminal decision that can't be undone. You can't put someone back into a plan. You may end up having to pay restitution, or try and put people back in the place that they were based upon some form of economic payment. But that's not the same thing as being able to put somebody back into a plan once they've rolled out. So with that kind of baseline of analysis that attaches irrespective of the DOL components, what we're seeing, I think what Victoria is saying is, look, there's a certain level of analysis that we're going to have to undertake, either as a fiduciary if we're an investment advisor, or in best interest if we're a broker-dealer. And then I think even in the insurance context, to the extent that more and more states have adopted the NAIC model as well for purposes of sort of compliance with best interest concepts as well, when making recommendations of insurance products, you end up in somewhat of a similar space insofar as, rather than trying to arbitrage different products or different transactions, whether it's insurance or securities or investment advice or brokerage advice, we're going to need to paper, and from an enterprise standpoint, it's going to be easiest for us to operationalize a system that doesn't have variances in it. If we're going to have a client, a prospective client that we want to have a long-term relationship with, whether and to what extent the decision to roll over or to transfer an IRA from another institution to this institution, we need to be able to show what the attributes are that we offer, the services here, not just sort of cost savings, but collectively what makes this better for them. And I think that that's as equally true of a rollover transaction to an IRA as it is from an IRA to an IRA. What makes our product offering, our services offerings better? And so it's the documentation of that I think has sort of raised the bar, which is what the regulators were hoping to achieve. So whether you look at it from a lens of what is DOL expecting from us versus what is the SEC expecting from us versus what is the state insurance regulator expecting from us, the documentation is reaching sort of a focal point where it's going to look fairly similar, or should, within the systems in terms of what have we done to justify this recommendation, and can we back it up if and when asked for it from an examiner standpoint or in our own internal audit processes.
Amazing. Dave, that's extremely valuable advice. Armin, looking at it from a practitioner's perspective, you've obviously felt the yo-yo of, hey, today there's a rule, tomorrow maybe not, it's going to be stayed. Can you walk our audience around what's been your immediate reaction, and what do you plan to do moving forward given the recent stays?
Yeah, absolutely. Actually, I just want to touch on something that David said, which I think is really interesting, is just this general idea that we are seeing a convergence in the industry as a whole, right? So, I mean, it used to be, 20 years ago, where the sort of the broker-dealer side, the investment advisor side, the insurance, state regulator side, they were very different animals. But as as time has passed, there's sort of been this convergence of these different areas of the financial industry, and I think this rule is just one of several other sort of attempts and efforts that have happened over the years to kind of contribute to that convergence. So it is interesting. And I mean, to some extent, I think it makes some sense, right? I mean, the concept of doing things in the best interest of your client makes sense. and obviously it makes a lot of sense to, me from the investment advisory side, because we've always been fiduciaries. This has just kind of been our standard, practice. But I think it is something that makes sense, and we're seeing it. And to David's point, really what I would love to see, and one of my reactions, I guess, would be that, I think as we move forward as an industry, a cohesive industry, it would be great to have a sort of a standardized approach to what this looks like. Now, obviously, it's going to vary slightly because the rules are different, whether if you're on the broker-dealer side versus an investment advisor, or if you're on the state-regulated insurance side. But I think that it really, we're going to start seeing some similarities. We're going to start seeing some sharing of, likely language and best practices and things like that are going to start happening. And frankly, I think that really speaks to just kind of where the industry is going as a whole. So Alphastar, for example, I would say probably 99% of our current advisor reps that affiliate with our firm also, as an outside business activity, happen to be insurance agents. So they work with fixed index annuities and things like that. So they are affected by both sides of this rule. And so that's been an interesting one for us, is just to kind of keep an eye on, first of all, the recommended changes that the DOL was trying to push through that obviously got stayed now. I mean, that would have made some significant impact on us from the outside, because our advisors, who would have also had to have comply with the insurance side of that regulation, would have been affected by that. So we actually wrestled with this a little bit, trying to understand how does that affect us as an investment advisor when we have this group who does work with insurance. Do we take on more of that responsibility so we can have some insight, supervision, control over it? Do we distance ourselves from it because there's some additional liabilities, legal liabilities that come along with it? So there was some conversations that we had to have, and I'll say those are conversations that that haven't really been finalized yet, and we continue to move forward with those. But it's certainly all very interesting. I will say I was looking forward to some of the potential relief in the IRA to IRA side of things, where we didn't necessarily have the same disclosure requirements. But to Victoria's point, regardless of the DOL rule and the disclosure requirements, I mean, we do still have an obligation to demonstrate best interest. And again, to Victoria's point, the only way to demonstrate that is if we have documentation. So certainly having this, some these mechanisms in place to comply with the DOL rule, did address that requirement for documentation as well. Now at Alphastar, a significant amount of our business is actually, relates to the rollover side of things. So, just one of the benefits to us of this rule and implementing the processes that we did to document is that we have an additional set of, when I was in law school, I had a professor that would always say, you want to have your belt and your suspenders on. So we have the advisors who have, their existing notes, and they document what they're doing and when they're meeting with the client. But in addition to that, so that would be the belt, we also have the suspenders, which is, using our suitability form and, the disclosures to the client to demonstrate additionally that we have met our best interest. The other side of this, I would say, is, or another point to this is, especially for our specific business. So we work with independent advisors. So our model is one where every advisor office has their own unique brand. They have their own unique marketing. They have different sort of ways that they work with their clients, and their internal documentation is different. Their systems are different. And so while they all take notes and they all have ways to demonstrate best interest, it's not universal. And so one of the benefits of the DOL rule for us has been that, at least to the extent of any kind of transactions that involve a rollover, we have this universal approach. And you can lay it out side by side, and it's very easy to compare. It's very easy to report. So it's been very good for us in that sense. So I would say, back to your original question, I guess for me it was a little bit of a relief just to stay at this point, because of the complexities for our group. You know, I wanted more time to really just digest it, work with our advisors to see, you know, what would be best, work with some of our partners on the insurance side, to try to come up with a solution that makes sense for everybody. So the stay is a relief. I don't expect this rule to go away. So I think, you know, I would just recommend really as an industry that we should keep our mind, you know, just keep our mindset on this thing and continue to try to come up with ways to solve for compliance with this, because I don't believe it's going to go away. So that's kind of where we're at.
Thank you, Armin. Maybe we're at the approximately 30-minute mark. Maybe it's a good opportunity to engage our audience and pop up a poll question. You know, what is your strategy in response to the recent court stays? You're either ready, you're sort of somewhere in the mix, you're almost there. It's almost like watching the stock price quotes going across your screen. Let's give it 5 more seconds. We've got 60 responses so far. This is fantastic. All right, 45 seconds. It looks settled. Share results. Pretty interesting stuff. I'll have to stop share and go back here. Okay, can you all still see my PowerPoint? Perfect. So Armin, you talked about a few points related to your firm's strategy, and you touched on the importance of technology here. And Randy, as you're sort of meeting and you know, supporting a lot of our clients, what are you hearing in the marketplace? How are our clients tackling the sort of the yo-yo scenario here? And then what do they see as the best steps going forward?
Great question. A bunch of different ways this could go, right? I'll try to take a couple of them. One is we're hearing a lot of benefit, and we're seeing a lot of action to move forward with a digitization or a digitizing of your process, not just because there might be some pending regulation, but because you get so many more benefits from it. Right? If you have a manual form, you're probably struggling with this today around quality of data, difficult process, hard to adopt. Nobody likes filling out more paper. I get a lot of random handwritten answers that are inconsistent, right? So being able to take a step, maybe not back, but to the side of the regulatory driver and saying, is this also an opportunity to consider just improving your process overall, giving your advisors more predictable, more efficient processing, more user-friendly, giving you on the home office side a more data-centric approach. So now you get into the potential for data trending, data analytics, supervision becomes easier. Where your data lives, if you have an advisor that leaves, or if you have a bunch of independents, that becomes easier because it can be centralized. Like, there are just so many different tangents so many different benefits that can come from digitizing your process. We're seeing a lot of that, right? Regardless of where this rule ends up, there is still a desire to just make the process better. Help me improve my recruiting. Help me improve, fill in the blank. So that's a huge, huge thing I want to make sure I talked about. The other piece that you mentioned, kind of the back and forth around where the landscape is going to go and how our firms are thinking about this. We do have, a community that's kind of been built up here. We've got a working group that's talking about this stuff, sharing best practices, sharing ideas, which is another kind of check the box win for, kind of embracing some technology solutions here. But really what it comes down to is making sure that you've got the capacity or the ability to react with whichever way the wind is going to blow, and however you need to modify your policy and procedures, making sure that you've got a solution that's going to react with you and do so, fairly efficiently and in a timely manner. And I'll throw one example out there. I know Armin's been talking quite a bit, and we've had some good on the side conversations around this whole IRA to IRA transfer, right? I mean, from our perspective, we've got a good example where the folks that use our application can be a little bit deliberate about how they want to treat the IRA to IRA differently than the plan to IRA, for example, have a consistent data collection, but treat the disclosure or the documentation a little bit differently, just because of how the framework is established. And so, things like that from a technology provider makes the compliance officer's job a little bit easier, and you can start to have a little bit more freedom and control and over your policy and procedures and how you implement them to look at what's good for the advisors and the supervisors as well.
Yeah, I want to jump in on what Randy's saying here, because I think this was actually an interesting challenge for us, and one of the reasons why I was very excited about the fact that we had actually shifted away from the sort of the old school paper approach to disclosure and documentation for the DOL rule to leveraging technology. When the new the changes to the rule were first introduced, that was the time when I just looked at it and said, we've got some work to do, but the fact that we have this technology already in place, we have platforms that we're working with, is going to make that transition and any kind of pivot that we need to make that much easier. And so that was a huge difference for us, was to I'm guessing there's probably a good number of people on this call who are compliance officers, CCOs and so forth. So I'm sure all of you have at some point your careers gone through the experience where you're going, I'm the only person here, right? I'm a one-man show, one-woman show, like that's it. And you're trying to find the most efficient ways to do what you do on a day-to-day basis and to stay compliant. And honestly, the technology has been so helpful. I mean, and look, the technology has to be good, right? It's not magic. You can't just have any platform that is going to solve all your problems for you. But the right technology was something that's been designed and crafted the right way and thoughtfully, with the rule in mind and the industry in mind, and is supported, by a service team that is able to really kind of help you implement initially and any ongoing changes, both as a result of your business growth or regulatory changes that come up. I mean, the combination of those things together, it's key. And I don't know how I would do my work, and I've got a sizable team here at Alphastar, but even with a sizable team, I mean, I don't know how we would have done this, easily, I guess. But with the technology that we have in place, it makes things, I was able to sleep well at night knowing that it was going to be a much lighter lift to get us, into a place of being compliant with the new changes, which ended up not happening, but so.
But Armin, isn't that equally true, not just at the point of sale in terms of the rep filling out information and getting it into the system, making things a bit more seamless for them to the extent, whether they were doing it manually or they're doing it on the system, the migration to a technology platform also makes the supervisory process a little bit easier, right? You don't have to go hunting and pecking for forms which may or may not have been loaded in the system. It's a centralized technology platform, so it's at least more accessible at the next stage of review. And then as part of the annual retrospective review, or from an audit and testing standpoint, if you're doing periodic analysis, let's say quarterly, for purposes of ultimate compliance with the annual retrospective review, and you're saying, hey, how good are we doing? What is the quality of our, not just compliance, but the quality of the recommendation by folks at the point of sale? Isn't that sort of the technology platform providing you the ability to look at that at these different points in the process? So Back end, easier for compliance, audit, testing, annual retrospective review. Middle management supervisor can access and take a look at transactions in real time in terms of reviewing and or approving if it's a pre-transaction completion review or post-transaction completion review, and then at the front end. It seems like it's all about sort of centralizing information to make it easier to manage.
Yeah, absolutely, absolutely. And it's an interesting point that you bring up. I mean, we when we were looking to make a switch, from the traditional, so and when I say old school paper, I mean PDF. It's still digital, but it's not technology,
Yeah.
right? So, and our PDFs were built into a DocuSign account opening process. So there was some tech around it. There was fields that had to be completed, and if they were not completed, it wouldn't allow the application to go through. So we were able to build some controls from that perspective. But to your point, we didn't have the the ability to leverage all the tools that we now have with with the technology that we use, and reporting is a big part of it. I think the books and records is a huge part of it. So we have about 120 advisors that we work with, and if they all have to go through the same system. It's all the same funnel, and every time a form is submitted, disclosures are made to a client, that document is saved on a database, with and we use rollover analyzers, so it's saved on rollover analyzers, a database, and then I can go in there at any time, or frankly, anybody on our team can go in there, including our our operations team. That doesn't have to be limited to your compliance department, but they can go in there and just double check and go, hey, you know what, an account just opened, but we don't have a form on file. So they'll immediately respond to that, go to that advisor and say, hey, we know that you didn't submit this, and we'll get that submitted. So it's fantastic, to your point, because it's live, right? So we can on the spot have controls in place where we can catch something at the very onset, and to me that's a huge deal, because it was a very easy way to implement a control at the upfront to then reduce the workload on the tail end. And again, I'm going to go back to the example. Many of us on this call are probably one-person compliance departments, or maybe there's two of you, and you're just you already have enough on your plates. The idea of having to go back and do a retrospective review on an annual basis and to dig through a ton of paper, emails, I mean, however it is that people are sort of keeping these records, it can be extremely time consuming. It's imperfect in many ways, depending on the ways that the mechanisms that are in place. So when you have a platform that is leveraging the technology that's out there and is able to keep all these things available at your fingertips, it's a game changer. And for us, the retrospective review is it's very clean. We catch everything at the onset. It's not perfect. Things do slip through, and when we catch them on the retro, we fix it. But I can tell you, I mean, the first year that we did this, we did it with the old PDFs, and it was a very different story. We had a lot of stuff to correct. And on the other side, now that we're using technology, just leveraging the power behind the technology and the resources that are available with it, it's a much cleaner process. It's a quicker review, and frankly, I think it's a lot more effective, because nothing is slipping through. We're able to see everything for the most part. So, yeah.
Fantastic. And I mean, the data I've got on the screen here talks to some of those, I'll call them, early wins as a result of adopting technology, Armin. When you look at the level of activity, or I'll call it rollover volume, as well as approximate AUM growth that's being recommended through rollovers, when you have access to that data, you can track pretty much the level of growth across your firm. And then interestingly enough, it's sort of this regulatory compliance construct of complying with Reg BI or the DOL's retirement security rule becomes that opportunity for you to do that. Any sort of observations in terms of the level of growth you're seeing across your firm leveraging this technology?
Yeah, I mean, what's interesting, I was thinking about this actually just this morning, but as a result of just this rule being in place and all the conversations that we have on a day-to-day basis about the DOL and rollovers and what's required and all those things, I think to some extent it's actually opened up some of our advisors who previously weren't weren't getting these kinds of clients, rollover clients, to go, hey, you know what? This is actually a whole other avenue of, building clients that I wasn't even thinking about. And so I think I would say some of the growth that you're seeing on this chart is attributed to just awareness. But then awareness only goes so far, right? Without the ease of implementing that new client into our platform, that awareness stays where it's at. I mean, people want to take the path of least resistance, and so I think just having the program that we have in place, and how easy it is for our advisor reps to be able to have that conversation with the client and to complete the form as part of the account opening process online, submitting it right there. It's just makes this whole process easier. So where somebody may have in the past, and I'm just going to use this as an example from the early days, when we didn't have technology, we had to spend an exorbitant amount of time to go through and find Form 5500s and industry standards and all those different things that you needed to be able to do an appropriate comparison between the various fees and all the other things that we're required to do from the DOL rule. And so it was time consuming, it was burdensome. And frankly, I think there are people who would probably look at this and go, you know what, it's not worth my time to speak to this person about a rollover, because I have to spend 2 days, hunting all this stuff down, spending time on the phone, tracking information down. I can just go talk to another client who has assets just sitting there that's not in a rollover, right? But now with the implementation of the technology, we just use a drop-down menu and we select the firm that we're working with, right? So let's say the person used to work for Twitter or something like that. You just drop down the menu, you pull it up, you pull up their 401k, all the information automatically populates. I don't have to call anybody. The advisor doesn't have to call anybody. We don't have to chase anything down. The client doesn't have to go back to a former employer, which can sometimes be, it's an inconvenience. They don't want to do it. And so that's really helped, us and really helped kind of position us for growth in that way, because rollovers are a lot more, easily achievable now. So from that perspective, I think it's been a big help. And then, obviously, this is just a big part of our business already. So there's certainly been, as they say, a rising tide lifts all ships. So I think, some of that has to do with the growth that we see here as well. I do want to point out, the 442 million versus 346 growth year over year. Those are approximate numbers. So the way our system works is that our advisors will sort of select what the anticipated amount coming in from the rollover is going to be. So it's not an exact number. It's there's a couple of dollars off here and there, but generally speaking, it's fairly accurate.
Thanks, Armin. Always love the legal sort of qualifiers. The spenders and the belts. Love it. Folks, we're unbelievably at time for our sort of prepared questions and answers. Let me plug one more piece of information before we get to our lightning round of Q&A. And by the way, maybe I've said this too many times in today's conversation. If you have questions, leverage the chat box. We'll get to them right away. So following today's conversation, when you close out the Zoom session, you're either going to get a prompt out via the Zoom panel or where did it go? Or the your web browser. Or in that panel, you will have an opportunity to request a webinar summary in writing, as well as an opportunity to engage Armin via a dedicated session to talk about Alphastar's journey, how they went or transitioned between a PDF process, as Armin, you've shared, to a digital process. So that's always an opportunity for you to continue your engagement with us. With that said, allow me to transition to the Q&A session. There's been some really good questions throughout today's discussion. I'm actually going to start with the last question that came in, at least that I saw, which centers around education versus a recommendation. Now, if quote unquote, maybe Dave, since you're in the practice of helping firms interpret those requirements, any thoughts on the recommendation versus education piece?
Yeah, let me start by working backwards from at least the proposal that stayed. If you make the recommendation of how rollover proceeds should be invested, whether, to include providing a retirement investor with an investment proposal for IRA assets after they are rolled over, even if no rollover recommendation is made, under the proposal, which is now stayed, that would be deemed to be covered advice giving rise to fiduciary status. Insofar as, we're now back in the state of play as of 2020, not 2024, and we're under the existing guidelines, education only is still a viable path. And whether or not something is education versus a recommendation is really kind of the call to action. How are you coupling the educational information and background that you're providing to people with some call to action? So it's, hey, here's just telling you what options are. This is what, we can do over here in IRAs. Here's our IRAs maybe allocated over here, kinds of things that we do. This is the differentiation between an IRA and a plan writ large. Okay, maybe getting a little bit closer to the extent you're starting to talk about how allocations may happen at your firm. But, at the point in time in which you're really sitting down to make it particularized, individualized to that person, you're crossing the Rubicon from general background, providing information about the differentiation between an IRA and a plan that a person may be in, and starting to deal with a person's individual set of circumstances. Now you're getting into the other elements of the test that makes this look more like a recommendation, not education. And I just observe, I think, a lot of firms going back to the state of play prior to the new proposal that we're saying, hey, I think we're going to sidestep 2020-02 insofar as we're just going to be education only. That's okay, as long as either A, programmatically, you can operationalize compliance with that construct. Hey, here's the materials that are authorized to be sent out the door. That's all we're going to do, and we're monitoring for that. But you're also disenabling your folks to do exactly what Armin was showing a minute ago, right? Taking the challenge of saying, hey, if we operationalize our process for managing an IRA, a rollover recommendation, there's opportunities for us to manage additional assets as long as we have the operational infrastructure to do it. That kind of goes to the core issue of why shouldn't we go after those dollars? Why am I constraining myself to be education only? Because we're really playing with fire to the extent that we believe sales force of 50, 100, 150 or more people can all maintain the education only construct, as compared to why should I disenable my people to make a rollover recommendation as long as we can tie out that it is in the person's best interest.
Really well said, Dave. Thank you. That's always a tough one. We get that a lot. And quite honestly, the guidance that we share with our clients is relatively principle-based. I mean, there's always, I hate to be that person who keeps saying, look at the guidance note, but in March of 2022, the SEC has a fabulous, in my opinion, very clear guidance note on account type recommendations. And I see the questions coming in, they're all around account type recommendations. And so the assessment of best interest, whether it's a rollover or a new account, whether it's a brokerage or an advisory account, some of those core principles and the best interest principles are foundationally outlined in there. So that will be a good resource for everyone. Let me just go back to the stream of questions here. Does it matter if the investment advisor has or does not have custody of the assets? Would the custody variable in your respective views have anything to do with this? I'll call it a best interest process, or even as far as calling it a DOL fiduciary process that's being required?
No, the receipt of compensation in a context in which you're a fiduciary, if you're an investment advisor, that implicates the DOL construct in the first place, right? If you're providing investment advice on a regular basis, such that you be deemed to be a fiduciary under DOL, and you're going to receive compensation if and when they open or establish a relationship with you, that's the trigger, the custodial component. is a different issue under the securities laws as to why is it you're having custody in the first place, and are you still complying with the surprise inspection requirements if you are, and all the other kind of stuff. But it's not the trigger for the DOL analysis.
And I would add to that, for discretionary investment advisors, in almost all cases, those rollovers should be considered recommended. That's the nature of discretionary investment advice. You're having ongoing conversations about the client's financial situation, investment objectives, planning for retirement. So even if the client says, I'm leaving my employment and want to roll my 401k to an IRA, the firm is going to make a recommendation as to specifically how to move forward. So there's not an intersection with custody, but certainly with discretionary investment advice, and you're making those recommendations, and you need to consider those under the DOL PT 2020-02.
Yeah, I want to add to that. Just at Alphastar, we pretty much all of our clients are discretionary. I mean, our client agreement says that we have discretion over every account that we manage. So we don't even permit the advisors to select the education option, or that it was an unsolicited rollover. In our instance, where our assumption is that every single one is a rollover recommendation for exactly the same reasons that Victoria mentioned. But I would say it's a very rare instance, and I would be very careful as a firm if you are seeing patterns where someone is submitting paperwork and it always says the same thing, that this was done unsolicited. That's a red flag right there. And by the way, guess what? That's where technology comes in handy, because if we're submitting these things by PDF, you may not be able to see those patterns. But when you're doing it through technology and you have reporting capabilities, I can go in there and I can look and see, oh, look at this. I've got 120 advisors, and these 3 folks over here seem to always get these rollovers, and it's always the client's idea. Well, that to me says maybe I should go talk to them and see, if that's really what's happening here, or are they just trying to avoid circumvent the rule by just claiming that the client did it on their own volition. So, I just make sure and be cautious of that if you're seeing those kinds of patterns.
Armin, thank you. Go ahead, Victoria.
Oh, I was going to say you're exactly right. And I think beyond that, you want to look at, are they providing the same explanation as to why the rollover is in the client's best interest, or the same investment product being recommended? Looking at the financial advisors individually, by branch office, across the firm as a whole. So the technology can really help you with that. And it's, it's a tool that I think a lot of firms should be looking at, because even if you're, incurring an expense, it's one that's going to make your advisors more efficient, and it's certainly more affordable than regulatory fines. So I'm a big fan of using technology in this instance.
Yeah, and guys, it's actually not that expensive. I mean, I want to be really honest here. There are a lot of tools out there that are they can really be cumbersome, from trying to get your CFO to sign off on it. But some of this technology is very reasonably priced, and when you actually do the cost benefit analysis, it makes a lot of sense. So I'd recommend looking into your options there.
Thank you, Armin.
If I can make a quick point on that, just I remember working with firms when we were talking about implementing systems for purposes of compliance with Reg BI in 2020, ahead of the compliance date. And there was a lot of thinking by firms at the time that, look, day one, I just want to get out the door and have facial compliance, and I'll worry about sort of the technological enhancements later. Right now, I'm just going to jerry-rig what I can out of my existing systems, like PDFs, modifications to account forms, and the like. And I think what we're seeing, particularly with clients, dual IABDs in particular, is not only, over time, the cost of some of the technologies come down, but it's really the extent to which you and your competitors are at least implementing more technological platforms for purposes of whether it's Reg BI compliance or it's PT 2020-02, rollover recommendations, et cetera. It's that when examiners come in and they look at your systems and they say, okay, we'd like to do a sample of 300 transactions of a rollover. Can you give us this information, and let's take a look at what you collected for purposes of documentation. And you can pull it together, but it's taking a little bit longer because it's all, even if it's on the system electronically, the platform isn't. The examiners are starting to have this, how are you realistically reviewing this? It raises questions in their minds as to the ability to supervise and audit and test the information when you're in a more manualized system. And that's true of PT 2020-02 rollover recommendations, it is as Reg BI compliance as it is NAIC for insurance transactions. So it's just this, the bar is rising, as well as the expectation of regulators looking at your systems to saying, how are you managing this volume? And you know, what confidence do you have in your annual certification if you're not chipping away at this volume on something other than an annualized basis? Sorry to go off on that on a bit of a tangent, but I think I just want to leverage the point you're making, Armin, and you, Victoria, as well.
It's so important. And David, thank you for raising that. Folks, we're a little bit over time. For any questions that have come through that maybe we didn't address, firstly, our apologies. We'll get to it. We'll follow up with you in due course. Victoria, David, Armin, and Mr. Barnes, thank you very much for your time. And thank you to everybody who invested some of your Thursday afternoon with us. Have a great day.
Thank you.